smile. Well, ladies and gentlemen, thank you for joining us tonight. You are, as we've mentioned before the camera turned on, you are our last interview of the evening. So we have saved a lot of energy for you. But in all seriousness aside, we know it is 6 o'clock on a Sunday night. You have families to be with. You have rest that I'm sure you need to catch up on. You have work that you need to attend to. And we do appreciate taking time out of your schedule to come down and interview with us. Well, actually, for all four of you, again. By way of introduction, furthest to my, well, usually I see it furthest to my left, but we're going to go the other way to be chivalrous. Furthest to my right, we have Lisa Brown. Next to her is Maria Maskall. Did I pronounce the last name correctly?
Yes, you did.
Lisa and Maria are running for the seat in Dept T, where there is currently not an incumbent. Next to Maria is Sandra Pomrenze and Nathan Gibbs. Sandra is the incumbent in Dept P as in Paul, and Nathan is running for that same department. Again, this is all family court. They don't handle criminal matters. They don't handle, slip and fall cases or personal injury, car accidents. None of that. First question that we normally ask, unfortunately, I know for a fact we've already asked all four of you because you were at our primary endorsements. So we're going to skip that one and jump right into it. And we'll start with Lisa and then just go down the line. Lisa, as you're well aware, approximately 60-ish% of litigants that come in the family court are improper person, they're representing themselves. What ideas do you have to make an already difficult situation, such as representing yourself in a heated domestic situation, what ideas do you have to make their journey through the court system a little bit easier for them to stomach?
Well, right now we already have a self-help center that I think has done a really good job. You can go online or you can go down right to the office itself. And they have forms for mostly everything that's covered in family court. Also on Thursdays you can ask an attorney for advice. When they come in front of you as a judge, you really have to be patient and listen to everything they have to say because they may not be as eloquent as some of the attorneys that are coming in. So I think the main thing is to be patient and listen, and you can guide them through, but you certainly can't give them any legal advice. But I think most of our judges do a pretty good job of dealing with people that represent themselves.
Okay. Maria, what ideas do you have to make the difficult situation a little bit easier?
Well, I'm a huge proponent of access to the courts for everybody, including all litigants who are unrepresented. I have done a tremendous amount of work with the Pro Bono Project, representing individuals who are unable to afford legal counsel, from the Pro Bono Rising Star Award in 1997 when I first arrived, I guess it was 98, to the Attorney of the Year in 2010. We also have the Lawyer Referral Service at the State Bar, who will refer individuals, or which refers individuals to attorneys who will give them advice on a sliding scale and will represent them on a sliding scale, as well as the Self-Help Center. I was on a forms committee with Justice Rose, when I first got here, developing forms for individuals who are representing themselves. I think for the large part, right now I'm a practicing attorney doing primarily family law, and I think that for the most part, a lot of the individuals who come to see me have no idea that any of these programs are available to them. And that's a huge, huge hurdle for the court. I think that it has to be made a little easier for individuals who come to the court to find out about the Pro Bono Project and about the Lawyer Referral Service. They see the Self-Help Center there, but they don't know about the other things that are available to them. So I would probably want to develop some sort of program to make sure that every individual in Clark County understands that they have other alternatives available to them.
Sandra.
Okay. Well, we have a lot of ongoing programs right now. One of my colleagues spent a lot of time with the assistance of other of my colleagues, actually created, and it's now on the internet, a video. It's in English, Spanish. I'd like to see it in Tagalog. to tell you the truth, because that's the second most common language before Spanish. I know I never pronounced it right, so I apologize. Tagalog, thank you. And along those lines, we have very few Tagalog interpreters, to tell you the truth, and that is a big issue for us. But we have that, and it's a video that if you have at least some semblance of English understanding, it really walks you through the system, and it was a lot of work on the part of this judge, and as well as on the part of the judges who participated in the video. This same judge also has been working on the self-help forms, because our self-help forms, unfortunately, were out of date by about 5-6 years or longer. You obviously know that, John, and so there has been a lot of work done. Then I, for my part, have been working on a committee. I chaired it up until the beginning of this year, on changing our rules so that they're a little more user-friendly, and they're a little more understanding, and they're not designed to have traps. And I know for self-represented litigants, they're just scared to death anyway. We've been working on the rules. We finally, and this is something that I worked on with another attorney, we finally have what I think is a really workable final financial disclosure form that really is, if you can read and write 6th grade, you can work your way through it and understand what you're doing. And so that's been a big move forward. Now in the courtroom, as I said, in addition to the interpreter challenges that we face, and well, let me talk about the interpreter challenges, because we do have many non-English speaking or English as a second language litigants. The county has limited resources to devote to interpreters. On the other hand, I think I, for my part, am very, very sensitive to somebody who can't afford an interpreter. So what I try to do is get an interpreter to come, and then I canvass that individual to determine whether I can appoint the interpreter to assist that person, and then the county would be billed by the interpreter. Because there's no such thing as free interpreters in any civil court in this state. We have them for criminal. We have them for dependency cases. We have them for delinquency cases, but we don't have them for any civil proceeding. And it's not just family, but also downtown in the civil division. So what I try to do is figure out if I can justify getting an appointed interpreter. And as I say, we don't have enough Tagalog interpreters. And did I say it
Do you
like
get
this?
volunteer interpreters?
No.
No?
And it's a big issue because
They do need a certification.
we want our interpreters certified because, unfortunately, the interpreters that aren't certified, they're busy giving advice. And I speak enough pidgin Spanish that I know it. And I mean, so you don't want the cousin or the son or somebody doing the interpreting, because it's not straight out, what did the judge say, what did the litigant say, and just repeating it, verbatim in translation. So it's a problem. It's very difficult to become certified. I know that. It's very, very difficult. It's a lot of work, and sometimes the return are good and sometimes not. So we do have what I think, I don't know what the county thinks, but I think it's a dearth of interpreters in a lot of different languages. We have a huge Chinese population. And I've had any number of individuals where English isn't even a second language. Sometimes they're elderly, and they've come to this country with family, and now they need to come in front of my court, and it's, aside from the fact that it's scary, and it's official, and all of that kind of good stuff, they have an inability. We have a couple of really great Chinese interpreters, but we don't have enough of them. And then you've also got the issue with the various different languages in Chinese.
And we do
go on and on. I'm sorry.
And we do tend to monopolize in the downtown court. We do tend to monopolize a lot of the Chinese interpreters. I know for a fact, because there aren't that many to go around, and there are just more. There's more need for them downtown than there is.
I would say our
Bonanza.
three greatest needs are Tagalog, Spanish, and Chinese. I do have somebody who comes in with a Polish interpreter. And there's other languages, but it's not the run-of-the-mill like it is with those three languages.
Okay, Nathan, regarding proper person litigants, how can we help grease the wheels? Grease the wheels is the wrong term. How can we help them navigate through
Okay.
a very difficult situation.
Okay, well, first thing, there's early, and I agree with the things that have been said about some of the things. I do think you need to advise them of the resources, because being an improper person, they don't know the system, they don't know what resources are there. I think those are all good ideas. I think early on in the case, we have what's called a case management conference, where the litigants come into the court and the judge will kind of get an idea for what the things are really fighting about are. And I think that you can have a very clear case management order that says this is when your list of witnesses needs to be produced, what you need to do, when you need to disclose documents by, when things need to be done. And I think you can help them a little bit without giving them legal advice by just saying this is my order and this is how it's to be done in our department. The other things I think are important is your temperament, because I think that you need to be courteous to people. As they mentioned, they're scared to death. I remember the first time I went as a lawyer for someone else. I was just out of law school, and I was scared to death. You know, I mean, it wasn't my life, but it was an intimidating thing. It was very official for someone else. So I wanted to do a good job. So you need to be very courteous. You need to take time to listen to them and give them the sense that even if you've read what they've said in their pleadings, that you want them to feel that they've been heard and listened to before you make rulings. And you have to also explain your rulings. You have to take time to say, these are the reasons I'm making these decisions. And then finally, I think that the other thing is it just naturally becomes less of a passive listener to evidence for evidentiary hearing with people who don't know the rules, and more of an inquisitional style. You have to, necessarily have to ask more questions of people because they don't know how to present the information.
I have a question.
Go ahead, please.
In your particular department, T and P, right, respectively, what do you think, where do you think there's room for improvement? I'm being very diplomatic. And what would you do to make that improvement?
And we'll start with Maria and then wrap around the other way.
Sure. I think that in the department that I'm running for right now, the incumbent is out as of the primary. So the room for improvement I see in that department is that, number one, you need someone who's going to be prepared each and every day when they arrive on the bench, someone who will make decisions and will not be continuing matters over and over and over again before a decision is made. I think also that if you look at the judges poll and the comments that were made about the particular judge who's in there right now, as well as my opponent, there's a tremendous room for improvement concerning knowledge of the law, temperament, basic rules of evidence and things like that. I think that with 24 years of experience as an attorney, 17 of those in family law, the particular experience that I've had, the exposure that I've had to pro se litigants, I think that I would be able to improve that department tremendously.
Lisa.
Okay. Well, what I can say is this. I have a passion for family law. It's what I've done in one form or another for the past 25 years. It's what I care about personally. It's what I care about professionally. And I will give it my all. I always pay attention to what's being said in front of me. I care very much. I care for my own family very much. And when your family is in front of me, I treat them as if that were happening to my family. And I'm very careful, and I take seriously the decisions that I make.
And we'll go to Nathan next.
I think that the biggest thing that needs improvement in Department P is the level of courtesy given to litigants and given the sense that they're listened to, those things. Now, someone may differ and say, hey, it's a judge. What's wrong with somebody that just really lays it on the line? I think that in family court, it's one of the roughest days of their life, and I think that they especially need courtesy so that when somebody's going to win, someone's going to lose if you're looking at something like a custody decision over children. And if people feel that they've been heard, they have an opportunity to speak, and that they have been treated with some dignity then they're able to handle the result if it's adverse to their position better. They feel like that judge, they don't feel like that judge just didn't like me. They feel like the judge didn't rule in my favor, and they can look whether they want to appeal it or what they want to do, but they feel they've had a fair hearing. I think that's the most important area of improvement, is in the temperament of how the litigants are dealt with in the court.
Sandra.
You know, sitting on the bench is, this is my 10th year, and sitting on the bench is a constant process of evolution. Please don't think that if somebody gets to be elected a judge, as I was 10 years ago, that you get on the bench, you're magic, okay? In fact, you're not. And it takes a long time to develop a certain rhythm. And I would be the last person to say that I don't need any improvement. But I try very, very hard and very seriously, if there's an issue, to improve. I joke that some people questioned whether or not I was courteous enough. I think that courtesy is important as long as it's in the context of making sure that litigants truly understand where they're going. And I frankly don't agree that there is a winner or a loser, because my perspective on cases is that I want the winner to be the child. That's it. Now, however that shakes out between the parents in question, that's something I work with. I've had litigants come up to me, very funny, you know, when you're a sitting judge and somebody comes up to you and says, oh, you were my judge, you know, you're waiting for the next shoe to drop. But uniformly, they've thanked me. I had one person thank me, you were tough on me. But you know what, you got me on track. I'm on track with my kids, and I can't thank you enough. So, you know, courteous is fine. And frankly, I joke nowadays, because I was taken aback by the poll, I joke I channeled Gloria Sanchez, now Gloria O'Malley a little bit more. And I think I'm trying to be a kinder, gentler, but all at the same time, I've got to try to protect these kids. Their parents aren't focused on them, they're focused on each other. And they forget that these kids have hearts, minds, and souls. And part of my job is to remind them. Can you remind them saying, oh, please, okay? No, you got to remind them by saying, these are your kids, you got to listen. Mr. Parrish knows I have a bunch of anecdotes that I tell on a regular basis. Now, I don't do them to hear myself talk. I do them because I'm just trying to redirect people a little bit better. I do think that I explain my rulings quite well. But obviously, people go in with their own agendas. That's not a criticism of litigants. They have something they want to accomplish, whether they want more time with their child, or they want to pay less money, or they just want to get out of an ugly marriage. They do have agendas, but if you understand the law, if you can apply it to the best interest of the kids, and then when you're done with what I call the kid issues, and I don't mean that with any disrespect, then you have to have the kind of solid business background that I had for almost 27 years before I became a judge. Because at the end of the day, you really, for all of these people, whether they have children or not, you are going to be unwinding a partnership. It's a partnership that has maybe some unique family law rules, but it's nonetheless, you're unwinding the financial life of two people. And so having those kinds of things as your background allows you to explain, allows you to understand, and allows you to be the best kind of judge you can be. And to me, the most important thing, other than the law and the Constitution, which I consider my roadmap, is making sure I'm fair. Fair it may be in the eyes of the holder when it comes to litigants, but fair is what really is doing the best job of applying the law. Even sympathies aside, you can't rule on sympathy. You'd be a lousy judge if you did.
And Sandra, I want to reference something very quickly. I hadn't said this earlier, I don't think. You had said that I'm aware that you have various anecdotes that occur in your courtroom. I don't have any pending cases in front of you. I think the last time I was in front of you was...
I mean, maybe 5-6 years ago.
Might have been 3 or 4, but it was several years ago. I think I had mentioned this at our primary. Nothing has changed since then.
Mm-hmm.
If somehow... Obviously, this doesn't apply to your race in Dept T, although I don't have anything in front of Judge Nathan either. I haven't for a long... I don't think ever, quite honestly. But obviously, both Nathan and Sandra, if that changes, if somehow I do get a family law case, God help me, in the next month, and it happens to be in Dept P, I will not participate in the actual deliberations regarding the endorsements, but I'm pretty confident that's not going to occur. I can kind of control whether that's going to happen, and I got it on good authority. It won't. Just want to inform you of that for test
We
the
did have
appearance
that
of impropriety.
discussion, yes, I remember it.
Yeah, nothing has changed since then. A couple of you have already brought up, before I go into that question, Freddie, did you want to jump in, or Kevin? Okay. A couple of you have brought up God bless the RJ poll survey, however you want to call it. What ideas, some of you have been subjected to the RJ poll, others if you haven't, and we'll start with Sandra and rotate back around the other way. What ideas do you have, Sandra, to make the poll a more accurate assessment of the job that judges are doing while they're on the bench? Or alternatively, what ideas do you have to make it a little more easily digestible so that civilians, lay people, non-attorneys, will get a better sense of how the judges are doing their particular job?
It would be better if it was even marginally accurate. But the problem with the poll is that it is blind and it turns into a bully pulpit. It's not unlike, the internet now, and people post stuff, and there's nobody to call them on it. One thing that would assist the poll in its reliability was if there was some way to demonstrate that an attorney who's submitting an evaluation actually appeared in front of that judge. Anybody can fill it out as long as you have you're licensed by the state of Nevada. I don't know that the questions really flesh out what a judge does. So I think it would be helpful to really take a hard look at the questions. I frankly think that the retention question sounds like a popularity contest, as opposed to why do you think so? I mean, what makes a judge? There was an Article 3 commission commissioned by the Supreme Court that was trying to come up with a fair, balanced, and realistic way to evaluate judges. They were talking about having retired judges from other states come in and observe judges and get a sense of what they're really doing. That just kind of petered out, and it's kind of a shame. I think that revamping of the questions, some guarantee that the attorney who was filling out the evaluation had actually had some fairly recent experience. I think there's a perception among some attorneys that it's a win or lose situation in family court. And I think that if you don't win or you come in unprepared, you may be embarrassed. And it becomes somebody's fault other than your own. But I would like to see a revamping of the questions, some real hint of, for example, I think one of the important things that is not evaluated in that poll, how productive is a judge? What's their case, how many cases do they have? What's their caseload? How quickly are they turning them over? How quickly are they making decisions once they've had a trial? How many things are they taking under advisement and then sitting on? Are they prompt to court? Do they spend their time in court? Do they walk in prepared, having read what the parties filed, and have an understanding of what goes on? Those aren't the questions that get asked. It's unfortunate, because that is the measure of a judge. That really is a measure. How sound are their decisions? That happens to be one of the questions, by the way. By the way, I did pretty well in that one. But what I'm saying to you, and frankly, I've had this discussion with the bar, and not just me, other judges. We would like to have something that really measures a judge. So that there is so when a judge is reviewing it, whether they did really well or they didn't do so well, they understand what needs to be improved and they understand how viable it is. The other final thing is there's got to be incentive to get all the lawyers to participate. The problem is when I have 600-700 lawyers appear in front of me, or any of the other family judges, and like maybe 100 participate in the poll, how is that a measure? It's not. So those are the problems with the poll, I'll be perfectly honest. Do I think judges should be evaluated? Absolutely. Should there be a fair and reasoned way to evaluate them that makes sense to the litigants? By the way, one other thing. You mentioned that 60% of our litigants on both sides are pro se. And then for another 15 to 20%, they're lawyer on one side, pro se on the other. We don't even ask those folks, the ones who are really affected, how was your judge? Was your judge fair? Did your judge listen to you? Did your judge make a decision that you can live with? How did it impact your kids? We don't ask them. We don't care what they think, and yet they're our voters. They're our community. Their kids are our community. Their kids are our future. We don't think to ask them. And that, to me, is a tragedy.
That's been brought up. That particular issue, or point, I should say, has been brought up several times today, and it's a good question. So, Nathan, how do we improve upon the RJ survey?
Well, first of all, I want to say that my experience as an attorney has been that they are fairly accurate in the sense that the existing poll matches my own experience with the judges. There's exceptions, and I think that it does matches my experience with the incumbent in Dept P. There are ways that it could be improved, and my thoughts are a couple of things. I agree with Judge Pomrenze. I think that you need to get information from people who've appeared in front of the judge recently a certain number of times, and perhaps you could either have the survey indicate that the person's asked how many times you've appeared in front of this judge in the last 6 months or last year or something like that to get a baseline, or only answer the question if you've appeared in front of the judge within the last year. So for example, that would exclude someone like yourself, Mr. Paris, that hadn't been there recently, and you wouldn't have a recent experience with Judge Pomrenze because you haven't been there for a few years.
I want to, and I'm sorry to catch up, I want to say it says within the last year or 2 years, or since the last survey. I think it does limit the time frame.
But it doesn't verify.
So
there is no verification, I agree.
I don't recall it, but anyway, you could have more information. You could also ask how many times have you exercised a peremptory challenge of this judge. As you're probably aware, there's been some discussion about that. If a lawyer feels like, I just don't want this judge on my case, you can pay a pretty hefty fee within a certain time frame and get them off your case. And the idea among lawyers is that if the number of people don't even want to take a chance with a particular judge, then that judge may have some issues or some biases, and that gives sort of a sense of that. I think asking that might be a good thing to know. And then the other thing is I think that they should ask the lawyers, what's your sense of what percentage of the time the judge ordered, if it's a custody case, joint physical custody, how often did the judge award custody to mom versus dad? Or they could gather this sort of information and incorporate it with the results, directly from the court system, which would probably be even better. So I think there's some ways to be improved, but I don't find them to be largely inaccurate as is in terms of what is there. There's just, as the judge indicated, there's some more information that would probably be valuable to people. And I agree that there needs to be more input from the litigants. There needs to be a method for finding out how they feel. And if they feel like the judge is doing great and the lawyers don't, then that should tell the lawyers something. Absolutely.
Lisa.
Well, I agree with Judge Pomrenze on what she said. You know what I think is a really great idea, and I hadn't heard it before, was to have retired judges from other jurisdictions come and watch you. I was on the bench for 8 years. I would say that if you pulled we have videotapes of everything we do, from the minute you walk on the bench and the minute you walk off. I would be fine with anyone randomly pulling one of those tapes and looking at it, because I know that I did the best I could every time that a family was in front of me. So I like the idea of having other judges evaluate your performance. I also think what's sorely missing is input from pro per litigants, and any litigant. They don't have to be pro per, anyone that was in front of the judge. I've also mentioned before that maybe even some of the court staff, you have court clerks that are in departments day in and day out. They see more of what the judge does than most other people. And as far as the survey that the RJ has, the methodology is flawed. They call it a poll, but a poll, if you poll someone, you randomly are called and asked to answer. This is not random. This is sent out en masse, and whoever chooses to answer, answers it. I know, well, it's been a few years now, probably six or 7 years since I've had one, but I'd say about 80 people responded. And you have to remember, we have thousands of cases, and as the judge said, a couple hundred attorneys that appear in front of you. And I do challenge the way that they handle the issue of whether this person actually appeared in front of you and how many times they appeared in front of you. If you look at how Martindale-Hubbell, how they evaluate attorneys, they reach out to certain attorneys, you're chosen randomly, and they ask you what your experience has been with that attorney. And you have to verify, even though it's all confidential from the attorney that you're evaluating, so again, it would be confidential from the judge that you're evaluating, you actually have to show that you have some experience with this attorney before you evaluate them. And the last thing I'd say is, in any type of survey or poll, or opinion poll is really what it is, I think you have to be careful of extremes. Extremely wonderful, extremely bad.
Maria, how do we make the RJ poll survey, whatever,
Well,
better?
first I'd just like to address this misnomer of the RJ poll not being random. I mean, saying the RJ poll is not random is like saying that voting is not random. Voting is available to every individual who's a registered voter. Only some come to vote, not everybody. And that's exactly the way that it is with the RJ poll. Everyone's invited to vote. Only those who choose to vote actually vote. It's no different. So to say that it's not random, I think is a little bit disingenuous. Secondly, I would think when I first came here in 1997, I saw individuals in the RJ poll and tried to figure out what was going on as soon as I became aware of the RJ poll and the voting on the judges. And it was really interesting to me to see that what people said about the judges when I went out and talked to different attorneys, 9 times out of 10, it was very accurate with what the other attorneys were saying. So my experience has been, like Nathan's, that the RJ poll is a reflection of what attorneys actually truly do feel about various judges in the community. Now, how to improve it? I think that if you add the element of actually having to prove that you've been before that judge, then the anonymity of the poll would go out the window. I do think that that individuals, and as members of the bar, I'm hoping that everyone understands that they have a responsibility to tell the truth and not to make up things and not to pretend like they've been in front of that judge and not to hold a grudge against that particular judge just because of something that happened 20 years ago. So if we take all, and for the most part, I'd say that most attorneys are at least ethical enough to adhere to those particular rules. So I would think that adding something about the peremptory challenges is a great idea. Other than that, if you take a look at the questions right now, we have questions on knowledge of the law, then you have questions on biasness, and I think that the questions are actually very well written, and I think that every attorney who reads them understands what it is that the RJ poll is looking for and votes on them honestly and fairly. I think that there are some questions that could be added to it, such as the peremptory challenge question, but other than that, I think that the polling allows the general public to get a feel for what each individual judge is doing on the bench and how it is that they are perceived by the legal community. Expanding that to litigants is probably a really good idea. My fear for that, of course, is that as litigants walk out the door, they'll be given a piece of paper, and one's happy, one's not so much happy. So, you know, you're going to get one person saying absolutely wonderful things, and you're going to get somebody else who's going to say horrible things. The problem with getting pro se litigants is that they have the one case that they're focused on, whereas attorneys, sometimes you appear before a judge, you win, sometimes you appear before a judge and you don't win. So I think that attorneys can kind of temper that and get a feel for why it is that that particular judge does what they do when the facts are the way that they are in that particular case, and they can temper that with all the other cases that they have versus an individual who's going to be looking at their one case and trying to figure out whether they liked the judge or didn't like the judge and on what basis they liked or didn't like that particular judge. So I think that that's going to be something that's going to be very difficult to temper if you open it up to the individuals. Although I think maybe perhaps if individuals were pulled a month or two after they appeared before the judge, maybe then once they're used to the new custody schedule, once they're used to the order that the judge had handed out, maybe that would be that would render more beneficial information.
The